In March 2021, a former royal aide faced the television question about what staff still could not discuss after working around Meghan, Duchess of Sussex, and the answer stopped at the point where palace silence could be mistaken for proof. If this account has been useful, subscribing costs nothing, and more stories like this one are queued. The bell notification means you will see them. The television frame held on the aide. The question invited an intimate account of life behind palace doors. What followed was narrower. Procedure could be discussed, public facts could be addressed, but the answer would not cross into private conversations, protected personnel files, medical matters, security arrangements, or advice given inside the royal household. That pause contained a real limit, though not necessarily the one viewers might imagine. It showed that the former aide recognized a boundary and chose not to cross it on television. It did not identify what private information existed beyond that boundary. Nor did it establish that the question itself had been built on accurate assumptions. Keep one distinction in view. A boundary on disclosure is not evidence that the questioner's premise was true. This is the line between silence and proof. A closed palace door tells you that access is restricted. It does not tell you what happened in the room. The same principle applies when a former employee declines to repeat a conversation. Restraint may come from a contract, the law, professional judgment, or several duties operating at once. The pause alone cannot choose among them. Leaving royal employment ended the daily work. The security pass could be returned. The office desk could be cleared. A name could disappear from the staff list. Yet information already learned did not suddenly become public property. A person who had handled a medical detail on Friday did not gain permission to reveal it merely because the job ended on Monday. That difference matters around any public institution, but it becomes unusually visible inside the monarchy. Royal employees work close to people whose official duties are photographed, recorded, and reported across the world. The same employee may also encounter family exchanges, health information, or internal advice that never belonged in public. Fame increases curiosity. It does not cancel privacy. Meghan entered that system after marrying Prince Harry at St. George's Chapel on the 19th of May 2018. The public image was bright and carefully observed. Cameras followed the couple as they left the chapel. Crowds filled Windsor. The ceremony offered a clear picture of a new duchess joining the royal family. Behind that picture stood an administrative structure with far less romance. Offices needed schedules. Correspondence had to be handled. Travel required planning. Staff dealt with papers bearing personal details and decisions that were still being considered. The wedding carriage moved through open streets, but the work surrounding the couple soon passed through secured doors, private desks, and controlled files. Royal household employees could encounter several kinds of sensitive material. Personal data might include contact details or information about an individual's circumstances. Official papers could contain plans before an announcement had been made. Security information might expose a route, a routine, or a weakness. Private family exchanges could reveal words spoken with no expectation that a staff member would later carry them to a newspaper studio. The sensitivity of that material did not depend on whether it became interesting to the press. A quiet conversation remained private, even if a later controversy made every sentence seem valuable. An employment record stayed protected even when the person named in it became part of a national argument. Newsworthiness and permission are different things. Palace service placed staff close enough to see both, then required them to know the difference. There was no single source for every restriction. An employment contract could set out duties connected to information obtained through the job. Data protection law governed the handling of information about identifiable people. Professional confidence required staff to treat certain communications as confidential because of the role in which they received them. Some positions could also carry specific confidentiality clauses or reported non-disclosure agreements. Those layers are often compressed into one dramatic phrase. A former employee refuses to answer, and the refusal is described as proof of a gagging order. Yet that description skips the basic questions. Which person signed which document? What wording did it contain? Which information did it cover? Did the restriction come from a special clause, an ordinary contract, the law, or a continuing professional duty? Ask what document is actually being cited before accepting the phrase gagging order. That question closes one important gap. These obligations were not uniform, and no publicly available document established one special blanket gagging order covering every employee around Meghan. Different jobs brought access to different material. Contracts could differ. Legal responsibilities could apply regardless of whether a separate non-disclosure agreement existed. A reported clause affecting one role could not simply be projected across an entire household. The distinction also prevents two opposite mistakes. It would be wrong to assume that every former employee had been forbidden to discuss every feature of palace work. It would be equally wrong to assume that resignation released every confidence acquired during service. The real position depended on the person's role, the information involved, the relevant law, and the terms governing that employment. That may sound less dramatic than a universal order stamped across every personnel folder. It is also more exact. Palace confidentiality worked through overlapping limits, each attached to particular information. The result could still be firm. A former aide might speak freely about an announced engagement while remaining unable to describe the advice that shaped it. The practical effect became clearer at Kensington Palace. The Duke and Duchess of Sussex initially shared an office with the Duke and Duchess of Cambridge. From outside the gates, the arrangement could look like one royal operation behind one brick facade. Inside, members of staff performed separate functions and encountered different slices of the couple's working lives. A communications officer might receive an incorrect date from a journalist and correct the public schedule. That did not permit the officer to repeat private words spoken while the schedule was being debated. The fact of an engagement and the conversation behind it belonged to different categories. One was ready for release. The other might remain inside the office. Human resources personnel occupied another position. They could receive a workplace concern, record it, and direct it through internal channels. Their authority to process that matter did not turn the underlying employment record into material for a television interview. The protected personnel file existed so that a complaint could be handled. Its existence did not give every observer a right to inspect it. Security staff faced a more immediate limit. An officer watching a palace vehicle leave through secured gates might know its route, timing, and protective arrangements. Disclosing those details could expose a vulnerability rather than merely embarrass a principal. Even after that officer left royal service, the risk created by publication could remain. A changed job title did not make a known weakness harmless. Notice how the answer changes with the job. A press officer, a human resources official, and a security officer did not hold the same information. The same question could therefore produce three different lawful answers. The press officer might confirm what had already appeared on the court calendar. The human resources official might explain how an internal process generally worked, while refusing to discuss an individual file. The protection officer might say almost nothing about movement through the gates. Their silence would have different causes because their access had been different from the start. The shared office arrangement did not last. In 2019, the Sussex household was formally created at Buckingham Palace. That administrative change placed the Duke and Duchess of Sussex within a distinct working structure. Staff responsibilities moved with it. Lines of reporting altered. Files and communications were handled through the new household rather than the earlier joint office at Kensington Palace. The move also shows why the broad label of former palace staff can mislead. A person might have served during the shared office period, after the Buckingham Palace change, or across both arrangements. Another might have worked only in communications. Someone else might have entered a personnel matter through an official function. Their knowledge would not match, and neither would the limits on what each could responsibly disclose. There was another complication. Information could pass through more than one pair of hands without losing its protected character. A private instruction might be seen by an assistant, discussed with a senior aide, and reflected in an unpublished paper. Each person's access came through work. The number of people who knew the information did not automatically make it public. This is where ordinary language can blur an important line. People often speak of palace secrets as if the only issue were an embarrassing anecdote whispered over dinner. The actual categories were wider and more routine. A mobile number, a draft statement, an employment note, or the timing of a vehicle could require protection without containing any scandal at all. Confidentiality, therefore, attached to the nature of the information, not simply to its power to cause embarrassment. That was the first substantive revelation behind the televised pause. A former employee could describe the machinery without displaying what remained inside it. Procedure might be open to explanation, while a name, a conversation, or a document stayed beyond reach. That separation protected royal principles in an obvious way. Staff entered rooms and read papers that outsiders could not reach. Without continuing duties, proximity to a famous household could become a saleable asset the moment an employee left. Private words would carry a price, precisely because the speaker had trusted the setting in which they were heard. But the same system also protected employees. A personnel file could contain an accusation, a response, witness information, and administrative notes. Publicly releasing fragments might expose someone who had expected an internal process. It could also strip away context, leaving the press to judge a workplace dispute from whichever page happened to leak first. That protection created a difficult tension. An employee might believe that public coverage had misrepresented what happened inside the office. Yet correcting the account could require disclosing another person's data or repeating a confidential exchange. The employee's own experience did not necessarily grant ownership of every record connected to it. For viewers, the frustration is understandable. A question is asked. The person on screen appears well placed to answer it. Then the words stop. The empty space feels meaningful because the audience knows the aide had crossed the closed palace door and seen something unavailable to everyone else. Still, the missing answer cannot safely be filled with the allegation already in circulation. Silence may preserve a confidence that has nothing to do with the claim. It may reflect legal advice about discussing an employment matter. It may simply show that a former staff member understood the continuing demands of the role better than the interviewer did. By early 2021, those distinctions were about to be tested under fierce public attention. Questions about the Sussex household no longer concerned schedules alone. Reports of staff departures had encouraged a wider argument about Meghan's conduct as a working royal. Accounts attributed to former employees began to circulate, while the documents and conversations that could settle parts of the argument remained subject to privacy and legal limits. One internal record would become especially important. In 2018, Jason Knauf, then working within the royal household structure, sent an email raising concerns about the treatment of employees. At the time, it belonged to the internal world of workplace correspondence. It was linked to named people, reported experiences, and the handling of staff concerns. In other words, it sat directly inside the category that demanded the greatest care. Once the existence of such an email reached the press, the argument would change. The public could know that concerns had reportedly been raised without gaining access to every underlying conversation, response, or personnel record. A headline could travel far beyond Buckingham Palace in an afternoon. The duties attached to the original information moved much more slowly. That imbalance was bound to create suspicion. Some observers would treat every refusal to elaborate as support for the allegations. Others would dismiss the reports because the full record remained hidden. Neither reaction solved the evidentiary problem. Publication could make a dispute public without making all the evidence available. The protected personnel file was about to become the central battleground because Jason Knauf's 2018 email would be reported publicly in March 2021 without removing the duties that still limited what former employees could say about it. And when it did, what entered the public record was narrow. The Times reported in March 2021 that Jason Knauf had written a 2018 email raising concerns about the treatment of employees. Knauf had worked in royal communications. His message became the visible document at the center of the dispute. Yet the newspaper's report established that concerns had been raised in writing. It did not, by itself, turn those concerns into a proven account of what happened inside the Sussex household. That distinction can disappear quickly beneath a headline. A reader sees an email on a screen, perhaps with names and personnel details covered by black bars, and the document feels conclusive. It is dated, it has an author, it contains specific claims. Those features can establish that a complaint existed at a particular time. They cannot establish that every event described in it occurred exactly as alleged. A written concern is evidence that somebody raised a concern. Its truth still has to be tested against records, witnesses, responses, and context. There were three separate layers. The first was the reported existence and content of Jason Knauf's email. The second was the underlying experience of each employee whose treatment had become a subject of concern. The third was any institutional finding reached after those accounts had been examined. Each layer required different evidence. A newspaper could report the first without gaining full access to the second. The public could hear allegations from the second without receiving a judgment from the third. Pause over those three layers because reporting an allegation is not the same act as proving it. This was where the protected personnel file mattered. Once part of the email appeared in the Times, it was tempting to treat the closed palace door as having swung open. It had not. The published material did not automatically release employment records held elsewhere. It did not waive another employee's privacy. It did not make every witness account available for quotation. Nor did it grant former staff permission to repeat private conversations simply because a portion of the dispute had reached print. An employment dispute leaves a much larger paper trail than one message. There may be correspondence about how a concern was received, notes of conversations, personal details supplied by employees, and internal advice about the next step. In a royal household, the people involved may also have discussed private family matters while trying to explain events at work. Publication of one document did not make that surrounding material public property. The original duty attached to the information could survive even when a newspaper had revealed that the dispute existed. That creates an awkward split. A former aide might see a claim about the office repeated across front pages, while still being unable to disclose the file that, in that person's view, supplied essential context. Another employee might want privacy precisely because the story had become famous. One person's wish to answer the allegation could collide with another person's right to keep an employment record out of public view. The louder the argument became, the less useful a simple demand to release everything proved to be. Buckingham Palace then announced that its human resources team would examine the circumstances described in the reporting. The announcement created the prospect of an institutional answer. Behind the palace gates, the relevant accounts could in principle be gathered and the handling of the concerns considered. For viewers trying to separate claim from fact, that examination looked like the place where the third evidentiary layer might finally appear. The question was whether the process would end with a report the public could read. It did not. The resulting review was not published. That outcome did not establish that the reported allegations were true. It did not establish that they were false. It meant the public did not receive the review's evidence, reasoning, or conclusions in a form that could be assessed. Buckingham Palace had acknowledged an examination, but the protected file remained behind the institutional door. If a report was never published, the public cannot honestly quote its conclusions. That limit matters whenever somebody claims that the palace review settled the issue. Without the report, an outsider cannot inspect which witnesses were approached, what documents were considered, or how conflicting memories were handled. The public record contains the announcement of an examination and the fact that its result was withheld from publication. Anything more definite requires evidence from another accessible source. Silence at the palace gates cannot be converted into a verdict simply because a verdict would make the story easier to tell. Meghan's position belonged in its own factual compartment. Lawyers for Meghan denied the bullying allegations. Her representatives described the reporting as a calculated smear campaign. Those statements were a direct rejection of the claims, not an institutional finding about them. In the same way, the reported email remained evidence that concerns had been written down, not a judgment overriding Meghan's denial. The unpublished review could not be used as a visible scale between the two because its contents were unavailable. The result was an unusually public argument built around material the audience could not fully inspect. On one side stood a reported message from Jason Knauf and accounts attributed to people connected with the household. On the other stood Meghan's denial and the accusation that the reporting formed part of a campaign against her. Between them stood Buckingham Palace, which had examined the circumstances but had not released its review. Each fact could be stated. None allowed the narrator, reporter, or viewer to manufacture the missing finding. Former employees were caught inside that gap. They had worked close enough to possess information the public wanted, but proximity did not erase their obligations. Privacy duties could cover details about colleagues. Legal exposure could follow an unsupported accusation or an improper disclosure. Workplace protections could require personnel material to remain restricted. Even when an individual believed that speaking would correct the record, responsible disclosure demanded more than a vivid memory and an invitation from a journalist. A television studio makes that restraint look strange. The lights are bright. The question is short. The former aide pauses, then answers only at the level of procedure. To the audience, the missing sentence can feel louder than the sentence spoken. Yet the aide may be considering several boundaries at once. Whose information is involved, whether the detail came from confidential work, whether it can be supported, and whether another person has any chance to respond. The televised pause shows pressure. It does not reveal which answer sat behind it. Confidentiality also served a legitimate purpose for royal principles. Household employees gained access that an ordinary visitor would never receive. They could enter offices beyond the public rooms, handle correspondence, and witness conversations during strained private moments. If every departure from service created a license to sell those scenes, employment inside the palace would become a waiting period before publication. A duchess, prince, or junior member of staff would have little reason to speak freely near anyone whose future memoir might depend on the detail. The principle was broader than protecting an attractive public image. Private conversations can include grief, health, family tension, and advice given before a decision is made. A communications aide might hear a remark that was never intended as policy. A staff member might witness frustration during a difficult day rather than a settled view of another person. Removed from the room and placed beneath a headline, either detail could acquire a meaning it did not originally carry. Professional confidence exists partly to stop privileged access becoming a private commodity. Royal service sharpened that concern, because the market for intimate detail was already waiting outside the gate. A casual remark linked to Meghan or Prince Harry could travel through a newsroom far more quickly than an explanation of the office procedure around it. Confidentiality forced the employee to treat access as part of the job, rather than personal ownership of every scene witnessed there. In that sense, the closed palace door protected ordinary human space inside an institution whose occupants were photographed whenever they crossed the pavement. But the same door could close against an employee. Suppose a former aide believed that public accounts had reduced the serious workplace experience to gossip, or had portrayed the aide's actions as disloyal. The most persuasive answer might depend on an email, a private exchange, or a colleague's protected record. Those were precisely the materials the person might not be free to reveal. Confidentiality could therefore preserve the principal's privacy while limiting the employee's ability to defend a personal reputation. That tension should not be tidied away. An institution needs channels where staff can report concerns without finding their names splashed across a newspaper. It also needs rules preventing servants from trading private royal conversations after leaving. Yet an employee whose conduct becomes part of a public dispute may reasonably want to explain what happened. The protected personnel file can shelter that person from exposure and, at the same time, withhold the evidence that person believes would provide vindication. The rule does not choose a hero. It creates a boundary around competing rights. The argument changed again after Prince Harry and Meghan stepped back as senior working royals in 2020. The dispute was no longer contained within a functioning shared royal operation. Former working relationships had ended or shifted. Public statements, legal proceedings, and press coverage supplied fresh reasons for reporters to search for people who had been in the rooms where decisions were made. A past office became an active source market, with every former aide potentially carrying a fragment of the story. Demand for insider testimony increased because the institution and the Sussexes were now presenting their positions from different places. Photographs still showed Meghan and Prince Harry at earlier public engagements, smiling beside barriers and greeting crowds. The office behind those appearances, however, had become part of a contested history. Journalists wanted the missing conversations. Viewers wanted a clear account of who had said what. Former employees still faced the same basic problem. Leaving the operation had not converted confidential knowledge into unrestricted testimony. Some former aides briefed journalists anonymously. An unnamed source could describe the atmosphere of an office, direct attention toward a document, or suggest which event deserved closer examination. Anonymity could protect a person who feared professional or legal consequences. It could also protect colleagues whose identities might become obvious from the detail. For a reporter, such a source might provide a valuable starting point. For the audience, though, the hidden name removed important tools for judging proximity, motive, and first-hand knowledge. Named figures generally stayed closer to information already public or to material relevant to legal proceedings. That did not necessarily mean they knew less than anonymous sources. It meant their words carried a visible owner and therefore a visible risk. A named former employee could be challenged, checked against documents, and asked whether the account came from direct experience. The person also had to consider contractual duties, professional confidence, and the privacy rights of everyone drawn into the answer. The contrast could make anonymous accounts sound more revealing. A silhouetted source in a quiet cafe could offer the detail that a named aide refused to repeat before a camera. But drama is not a method of verification. The source might be close to one incident and distant from another. A genuine memory might still be incomplete. An account might accurately describe personal experience without representing the wider office. When a source is unnamed, ask what can be checked beyond the source's own account. That question does not make anonymous reporting worthless. Confidential sources have often helped journalists locate documents and identify matters that deserve investigation. Their information can be tested against dates, correspondence, independent witnesses, and material placed before a court. The weakness appears when anonymity itself is treated as proof, as though personal risk guarantees factual completeness. A source can be sincere and mistaken. A source can accurately report one conversation while lacking the context supplied by the people outside the room. The absent palace review made that testing harder. There was no published institutional report against which anonymous accounts could be measured. The Times report supplied the known existence and described content of the 2018 email. Meghan's lawyers supplied a clear denial. Buckingham Palace supplied confirmation that an examination would occur. Those pieces established the shape of the dispute. They did not supply an accessible final ruling, and an unnamed briefing could not quietly take the place of one. This is the line between silence and proof. A refusal to discuss a protected record may show that a boundary exists. It cannot show what the concealed material would establish. An anonymous account may point beyond that boundary, but its force depends on what a reporter can verify outside the account itself. The decisive test was now a named former employee standing on the record. Which parts of royal employment could that person discuss? Which protected categories remained closed? And whether refusing a question proved anything beyond the existence of the boundary. The boundary did not disappear when a former employee sat beneath television studio lights and gave a name for the caption beneath the screen. It simply became easier to see. A named aide could be questioned in public, challenged afterward, and held responsible for the words used. Yet the material behind a closed palace door did not become public merely because the person who had encountered it had left the building. That distinction settles the question carried by anonymous briefings. An unnamed source may know something important. Protecting that source may be necessary, particularly where employment, legal exposure, or future work is at risk. Journalists often begin with such information, then seek documents or independent witnesses. But viewers cannot inspect an anonymous source's contract. They cannot establish the exact role, test the level of access, or examine the records said to support the account. Motive also remains difficult to judge. A former employee speaking after a difficult departure may be entirely accurate, partly informed, or wrong about events outside that employee's view. A colleague still inside the royal household may have direct access, but reasons to shape the account. Anonymity protects both people from immediate exposure. It does not tell the audience which description fits. That is why anonymous reporting can generate a serious lead without completing the evidentiary work. It may direct attention toward an email, a complaint, or a departure from Kensington Palace. It may prompt questions that would otherwise remain behind office windows. Still, a briefing is an account supplied to a journalist. A finding requires something more, such as records, corroboration, or a process capable of testing competing claims. Anonymous sourcing may offer clues, but it does not turn an allegation into a finding. Named testimony has a different strength. When a former palace aide appears under bright studio lamps, the public can identify that person's job history and compare later statements with the words actually spoken. Editors can request clarification. Lawyers know whom a claim belongs to. The source accepts a degree of scrutiny that an unnamed voice avoids. But accountability is not a master key. A printed name does not unlock a protected personnel file or release a private conversation from confidence. The former aide may be free to confirm a public date, yet unable to repeat what Meghan, Duchess of Sussex, said during a close meeting. Identity belongs to the witness. Confidential information may still belong, legally or ethically, to someone else. Ask two separate questions. Could this person know? And can the claim be checked? The first concerns access. The second concerns proof. A palace employee may satisfy the first test because a desk stood near the relevant office, while failing the second because no document is available and no other witness is prepared to speak. A distant observer may fail both. A named source does not collapse those questions into one. Some subjects could nevertheless remain discussable. Established public facts were generally the safest ground. A former communications aide could refer to an engagement already listed in the court circular, a household announcement released to newspapers, or an office change formally confirmed by the palace. Repeating what had entered the public record was different from disclosing the private discussion that produced it. General procedure could also be explained in suitable terms. Someone who had worked at a royal communications desk might describe how press schedules moved between offices, how briefing papers were prepared, or how questions from reporters reached the household. That did not necessarily permit the person to quote a duchess's private instructions, identify the author of confidential advice, or disclose an unpublished draft resting beside the telephone. A former employee could often describe a career in broad terms. The person might name a post, outline ordinary responsibilities, or discuss professional skills acquired during palace service. Even there, care mattered. Saying that a role involved media inquiries was one thing. Reconstructing an internal exchange about Prince Harry or Meghan was another. The dividing line ran through the information, not merely through the job title. Legal proceedings could create another route depending on the circumstances. Information lawfully relevant to a case might be placed before a court through witness evidence or disclosed documents. Judges, lawyers, and procedural rules then controlled how the material was handled. That setting did not convert an entire palace career into open property. It allowed particular evidence to be considered for a defined legal purpose. No single formula covered every former employee. At a royal communications desk, an aide might encounter press plans, draft statements, private correspondence, and advice about how to answer a newspaper. The risk lay partly in exposing internal decisions or attributing confidential words to a royal principal. Even an apparently harmless anecdote could reveal who argued for a particular response before the palace issued its public line. A human resources official occupied another position. Inside a locked cabinet, labeled folders could contain employment histories, complaints, contact details, health information, or records of internal discussions. Those documents concerned employees as well as the royal figures around them. Leaving the royal household did not make the content suitable for a memoir, a broadcast interview, or an off-the-record lunch with a reporter. A protection officer faced a sharper physical risk. A motorcade route, a security barrier, and the timing of a palace departure were not simply colourful details from an unusual workplace. Together, they could reveal habits or weak points. Information that looked stale to a casual viewer might still help someone map a routine. The consequences, therefore, extended beyond embarrassment or reputation. The applicable duties could vary as well. One employee might have a particular confidentiality clause. Another might be constrained chiefly by the employment contract, data protection obligations, or professional standards attached to the role. The facts could change again if material entered legal proceedings, if consent had been given, or if disclosure was required by law. The public phrase, palace confidentiality, covered several overlapping restraints rather than one identical rule pasted onto every staff file. This variation matters because the broadest claim is also the easiest to repeat. Reports sometimes referred to non-disclosure agreements as though one special document had silenced everyone around Meghan. No publicly available document established a universal Meghan-specific gagging order for every employee. That does not mean confidentiality was absent. It means the existence and reach of any restriction must be shown for the person and information concerned. The strongest objection cannot be brushed aside. Confidentiality can make proper scrutiny harder, especially when the institution controlling the process also keeps the result private. Buckingham Palace announced that its human resources team would examine the circumstances surrounding the reported staff concerns. The resulting review was not published. The palace windows went dark at dusk, and the public was left outside with no findings to read. That absence created a real problem. Employees who believed they had been treated badly could not point the public toward a released report. Meghan's representatives, who denied the bullying allegations and described them as a calculated smear campaign, could not answer a document the palace had not disclosed. Viewers were asked to assess an institutional process while being denied its final contents. Frustration was reasonable, yet frustration does not supply the missing pages. An unpublished review cannot honestly be described as clearing Meghan, unless its findings support that conclusion. It cannot honestly be described as proving wrongdoing either. The locked cabinet creates uncertainty. It does not allow either side to write a preferred verdict on the label. The same discipline applies to the interview in March 2021. A camera held on a named former aide after a question about life behind palace doors. There was a pause. To television, a pause is irresistible. It creates empty space, and audiences rush to fill empty space with motive. As evidence, however, that moment remained limited. The aide may have recognized that the next sentence would cross a professional boundary. Legal caution may have intervened. Loyalty to former colleagues could have mattered. Fear of consequences was possible. The person may simply have refused to expose another individual's private life for the sake of a sharper television exchange. The frame recorded hesitation, but it did not record the thought that caused it. Nor did the interviewer's wording transfer its premise into the witness's mouth. A question can contain an allegation, an assumption, or an invitation to speculate. Declining the invitation leaves those elements where they began, with the questioner. The protected personnel file remains closed, but its closed cover does not reveal what is written on the first page. Draw the line carefully here, because some information remained protected is not the same claim as nothing could ever be discussed. The distinction is the answer to the central question, and it is precise. Former staff could still be barred from revealing private conversations, personal and personnel data, internal advice, security details, and other confidential material obtained through their work. They were not necessarily forbidden from discussing every aspect of royal employment. The restriction depended on contract, role, law, and context. A press schedule already released to the public was not equivalent to a private instruction. A broad career description was not equivalent to opening another employee's file. This category-based answer explains why the former aide could discuss procedure while stopping before a confidential exchange. It explains why a communications employee, a human resources official, and a protection officer did not carry identical risks. It also explains why departure from palace service was not a clean break with every duty created during the job. Some obligations followed the information beyond the palace gate. The second half of the answer is just as important. A person's refusal to answer does not confirm the premise of the question. Silence may be consistent with several explanations at once. Unless independent evidence separates them, selecting the most damaging one is speculation. The absence of a detailed public rebuttal cannot fairly be converted into support for the allegation being put to the witness. Applied to the dispute around Meghan, the evidence therefore remains divided by type. Jason Knauf's 2018 email, as reported by The Times in March 2021, documented that concerns had been raised. It did not by itself decide whether each allegation was accurate. A complaint records the existence of a complaint. Testing its substance requires evidence from the people, records, and circumstances involved. Meghan's denial occupies a different place. Her lawyers rejected the bullying allegations, and her representatives called their publication a calculated smear campaign. That response established her position clearly. A denial must be considered, but it is not an independent investigation. It cannot substitute for the evidence that would be needed to assess each disputed event. Buckingham Palace's examination was different again. It had the potential to review internal material unavailable to ordinary viewers, but the decision not to publish the resulting review left its conclusions beyond public inspection. One cannot safely infer from that choice what investigators found. Privacy, employment law, institutional caution and reputation could all affect whether such work was released. Anonymous briefings may have reflected genuine staff experiences and may have helped reporters locate relevant events. The limits remain the limits of anonymous evidence. Restrained comments from named former employees carry more visible responsibility, yet those speakers may still be unable to provide the confidential detail demanded by an audience. These sources do not form a neat pile pointing toward one automatic verdict. They are separate pieces with different origins and different weaknesses. The fair conclusion is therefore narrower than either partisan version. The reported email cannot be wished away. Meghan's denial cannot be omitted. The palace examination cannot be treated as public proof when its result remains unpublished. Anonymous claims cannot be upgraded into findings, and a careful answer from a named aide cannot be forced beyond the words actually given. This is where the machinery of monarchy becomes visible. The institution depended on servants and advisors entering rooms that most people would never see. They handled letters, telephone calls, medical information, travel plans, and family exchanges. The work required intimate access combined with the discipline to behave as though that access were held in trust. That trust protected royal principals from having every difficult morning or private disagreement solved after an employee resigned. A duchess could speak to an aide without assuming that each sentence would later become copy for a newspaper. Prince Harry could receive internal advice without every draft appearing beside his photograph. For a household built around constant public attention, discretion was part of the working structure. The same structure could leave employees exposed when their own conduct or experience became contested. A former aide criticized in public might possess records that could add context but remain unable to publish them. A staff member who believed an internal process had failed might have few ways to speak without risking legal action, professional damage, or another person's privacy. The duty that protected the closed palace door could also keep the employee standing silently behind it. That tension has no simple cure. Full disclosure could injure people whose personal data sat inside the file. Total secrecy could shield poor management from scrutiny. A fair process would need to protect privacy while giving complaints and denials a credible route to be tested. In the Meghan dispute, the public did not receive enough of the palace review to perform that test for itself. The resulting gap attracted certainty from every direction. Supporters treated silence as evidence that the allegations had collapsed. Critics treated the same silence as proof that damaging facts were being suppressed. Both readings asked an empty space to do the work of documents and witnesses. The line between silence and proof was crossed before the evidence could support the journey. Look once more at what the silence actually proves, rather than what any side wants it to prove. The television frame returns to March 2021. A former palace aide sits beneath the lights. The question hangs in the studio, and the answer stops at the edge of material acquired through royal employment. No personnel folder opens. No private exchange plays back. No finding appears on the screen. In palace history, silence may conceal loyalty, fear, legal duty, or simple professionalism. It may protect Meghan, another employee, the institution, or the speaker. Those possibilities explain why the pause mattered, but they do not allow it to confess on anyone's behalf. Without independent evidence, the pause itself cannot tell the public which one.